Morning, everybody. This is Theresa Green in life. She was the mother of Octavius Hayes, daughter of Lyda Jones, sister to Loretta Tomlin, and Rosemary Jones, and she was a friend of those who knew her in life, like the Butlers. She worked at the Florida hospital in the labor and delivery department. The department of the hospital that's meant to bring newborns into this world and to help mothers share the miracle of life. That's what Miss Green did before this man right here strangled the life out of her. This is Theresa Green in death. After that man strangled her, wrapped her body in a sheet, threw her body in the trunk of her own car like a piece of trash, left that car at Walgreens, fled the state to try to escape the crime he just committed. That's why we're here, ladies and gentlemen, and that's why the defendant is charged with first-degree premeditated murder. Judge Munyon read you some instructions a few minutes ago when she explained to you the instruction regarding justifiable homicide. She told you that the use of deadly force is justifiable homicide and lawful if done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house which the defendant was at the time of the killing. There is no evidence in this case whatsoever to suggest that this killing was justifiable. And the judge told you earlier that it is your job to look to the evidence in this case that you heard from the witness stand and saw in the form of exhibits in making your decision. I believe the defense, even in jury selection and opening statement, said you need to look at the evidence presented in this case, and that governs your decision here. You heard evidence that Joseph Butler and Theresa Butler got into kind of a slapping thing in the apartment that night. You heard that they went on the stairwell and they tumbled down the stairwell at some point. You also heard that at the bottom of that stairwell, nothing happened. No one was screaming in pain. There were no punches thrown, no weapons drawn, nothing going on between the victim and the defendant. No indication that the victim was trying to murder the defendant or commit a felony upon him. Instead, they got up, they walked up the stairs, and they went back to Theresa Green's apartment. Additionally, ladies and gentlemen, you've heard evidence from Dr. Utz, the medical examiner, that Theresa Green, the victim in this case, was strangled. That is not the result of somebody defending himself. That is the result or the sign of first-degree premeditated murder. Also, ladies and gentlemen, people who are justified in killing somebody don't, after it's done, take the body, wrap it up, hide it in the trunk, and flee the state. People who are justified in killing somebody don't try to cover the killing up. This killing, ladies and gentlemen, was in no way justifiable. Judge also read to you an instruction, and you have them in front of you. You were reading along. Excusable homicide. An excusable homicide occurs when the killing is committed by accident and misfortune. Dropping a gun and the gun accidentally going off and hitting somebody and killing that person, that's an accident. That's misfortune. Wrapping hands around somebody's neck and strangling the life out of somebody is not accident. It's not misfortune. This is not an excusable homicide, ladies and gentlemen. There's no evidence to support that. So let's look at the elements that the state is required to prove in order to prove this defendant guilty of first-degree premeditated murder. Number one, Theresa Ann Green is dead. I don't think this element is going to be in great dispute. There's no question she's dead. How do we know that? Well, we know that the person found in the trunk of Theresa Green's own car was an African-American woman about the same body type and age as Ms. Green. We know that she is locked inside the trunk of her own car. And we also know that a fingerprint analyst, Howard Kuhn, compared known fingerprints of Theresa Green, which were rolled before she was killed, with the fingerprints rolled at the autopsy of the woman who's found in the trunk, and they match. So this element, I don't believe, is in dispute in any way. The state has proven beyond any reasonable doubt that Theresa Green is dead. The second element the state has to prove is that the death was caused by the criminal act of Demorris Hunter. So how do we know that it was the defendant who killed Theresa Green? Well, we know that the defendant and the victim were dating. Joseph Butler, Joyce Butler, Lisa Moore, and Octavius Hayes all identified the defendant here, Demorris Hunter, as the person that they knew back then as Mike. So we know the defendant back then was lying to everybody about his real name. But we also know that law enforcement showed each of those 4 individuals photo packs. And in position number 3 was a photo of this defendant, Demorris Hunter. And each and every one of those 4 victims, or 4 witnesses, picked the defendant out as the person they knew as Mike. So we know Demorris Hunter and Mike is the same person. Additionally, when the defendant was arrested and brought to Florida, his DNA was collected. And you heard from the DNA analyst that the defendant, Demorris Hunter's DNA, was found on the victim's watch in her apartment. So we know this man is the same Mike that was at the party that was dating the victim. We also know that the defendant's fingerprints were found in apartment number 9, this man's fingerprints. So again, we know this man is Mike, the person who lived in apartment 9, the person we've been talking about throughout the course of this trial. So how do we know that the defendant killed her? We know that the defendant was the last person to be with the victim when the victim was seen to be alive. The Butlers told you that there was a get-together at their apartment the night that all of this happened. The Butlers lived upstairs on the right in apartment number 12. Theresa Green's apartment was right across the hall, apartment number 11, and the defendant lived downstairs in apartment number 9. There was a get-together that evening. Joyce Butler had to work the next morning. She's like, we need to shut this party down. It's loud, the music's going on, I need to work, so we need to shut it down. Joseph Butler complied with her wishes, shut the party down, and for some reason, there was some kind of disagreement between Theresa Green and Joseph Butler around this time. And admittedly, Theresa Green was intoxicated, she was impaired, and she slaps Joseph Butler for whatever reason. Joseph Butler slaps her back. They eventually make their way out on the landing, where we see in the photograph. Something happens on that landing. There's testimony that Theresa Green kicked at the defendant maybe grabbed her, and they tumbled down the stairs. When they got to the stairs, down to the bottom of the stairs, again, they got up. There was no screaming, nobody was severely injured, no one was in pain, there was no fight, punches thrown, weapons drawn, anything like that. They simply got up, walked up the stairs, and went into the defendant and Theresa Green went into Theresa Green's apartment. So regardless of how impaired Theresa Green was, we know she was able to negotiate and walk up those stairs on her own with no problem. Once the defendant and Theresa Green went into Ms. Green's apartment, Lisa Moore told you that she heard loud voices. She heard some kind of arguing. Lisa Moore's 6-year-old son was in the Butler's apartment still. So she goes in, she grabs her son, she goes downstairs and puts her son in her car. She walks back up those stairs and she wants to use the phone to call her brother. She can't get into Mr. Butler's apartment. Either Mr. Butler blocked the door or whatever, she couldn't get in. So she knocks on Theresa Green's apartment door. Theresa Green doesn't answer. The defendant answers. And the defendant doesn't say anything like, oh my God, I lost my mind and Theresa's hurt. Come help, call law enforcement, go call 911, whatever. He says to Theresa Green, when she asks to use his phone, he says, it's best you don't come in. He didn't want her coming in to see what he did. Otherwise, why not let this young lady who has her son trying to use the phone come in for a second and make a quick phone call? That'd be a pretty good reason why he wouldn't let his friend, the woman who he was with this party with throughout the night, the neighbor's friend, the neighbor's daughter, come in and use the phone for a second. Lisa Moore told you she went downstairs again, checked on her son. He was okay. She walked back upstairs, again, knocks on Theresa Green's door. No one answers this time. I submit to you, ladies and gentlemen, Theresa Green couldn't answer at that time, and the defendant surely did not want to answer. Who was the last person to be seen with the victim when the victim was Joyce Butler told you that. Joseph Butler told you that. So did Lisa Moore. And remember, Lisa Moore was not drinking that night. And Lisa Moore is not suffering from the memory problems that her mother admittedly said she is suffering from. Remember, Lisa Moore told you that when she saw them fall down the stairs, they kind of slid down on their butt. She was asked, did you ever see Miss Green hit her head or on the way down or get injured? She said, no, I didn't see that. They slid down on the butts. And I expect the defense during their closing argument to bring up that these three witnesses, Lisa Moore, Joseph Butler, and Joyce Butler, had some inconsistencies in their testimony. And they have every right to say that because that's true. They did have some inconsistencies. They had some inconsistencies about some of these small details. How long did you know the victim? They had different answers. How long had you lived at the apartment? They had different answers. How long did you know the defendant? Again, they had different answers. What position were the defendant and the victim when they tumbled down the stairs? Some of their answers were different. Ladies and gentlemen, I submit to you that that's to be expected. This was 24 years ago this happened. It's expected that memories will fade and some of these small details will be inconsistent. But look at the total of their testimony. Look what was not inconsistent. Look what they were consistent about. They all said the same thing about what happened at the party, why it ended, about the slapping, about them falling down the stairs. Joyce Butler and Joseph Butler were consistent about the next morning when the defendant came and asked for Joseph Butler's help in moving the victim's car. The last person to be seen with the victim when the victim was alive was the defendant. So what happens the next morning? The defendant comes over 6:30, 7 o'clock, and remember this party shut down at like 2:30 in the morning, so this is only several hours later. The defendant comes over and he asks Joseph Butler for some help. He asks, hey, I need you to follow me and Theresa someplace in the car. He doesn't say where they're going. The defendant gives Joseph Butler the keys to this white van that the defendant had been driving, the white van that was owned by Henry Fields, a.k.a. Pete. Henry Fields had let the defendant use the van as he needed. So he gives Joseph Butler keys to the van. Joseph Butler gets in that white van. The defendant gets into Theresa Green's car, and they leave together. The defendant's leading. Joseph Butler is following in the van. This is the same van that was eventually found in Houston, Texas, torched, on fire. Joseph Butler said that this was a little unusual because the defendant didn't drive Theresa Green's car. It was also unusual that Theresa Green wasn't there. He didn't see Theresa Green at that point. Why? Because she was already dead and her body was stuck in the trunk of the car. So they traveled to Walgreens in Sanford. The defendant made arrangements to get rid of the victim's body. Body was wrapped in a sheet, thrown in the back of the trunk. That trunk was shut and locked. Law enforcement had to break the window to gain entry and then break the lock to actually get inside the trunk. The defendant didn't just drive the car a block down the street. He distanced himself. He made sure that this car was far away from the apartment, the place that he lived, and the apartment that the defendant and the victim were last seen together inside of. When they get to Walgreens, it's interesting that the defendant doesn't even get out of the car to go inside the store. It's not like they drove 15, 20 miles from Orlando to Sanford for him to go into this specific Walgreens to get something, to justify why they're going there. He doesn't go in, he doesn't buy anything. Joseph Butler goes inside to try to get some Alka-Seltzer because he's feeling real well. He comes out and the defendant is rummaging around the victim's car. Joseph Butler gets back in the van. The defendant then gets back in the van. And they leave this car here at Walgreens. The sole purpose behind this trip, ladies and gentlemen, is again to distance himself from this car and keep that car and the body inside as far away from the place that's associated with the defendant as possible. And he trusted Joseph Butler not to say anything, because Joseph Butler was a friend. Well, thankfully, ladies and gentlemen, when questioned by the police, Joseph Butler did tell the police what happened and did explain about the transporting of the car to Walgreens. Not only did the defendant try to distance himself from this car and the body of the victim that he killed, when he gets in the van with Joseph Butler, he says something very important. He tells Joseph Butler, "I messed up." Well, the defendant was right about that. Joseph Butler said, "Look, I don't want to hear anything else. I don't want to be involved." And this was the first time Joseph Butler said he actually felt concerned. He told you that there was some kind of a plan between him and the victim to go to the car lot this morning and drop the car off. But when the defendant came over that morning and asked Joseph Butler for help, he didn't think really much about it. But he didn't see Theresa. They don't go to a car lot, they go to Walgreens instead, which is weird. The defendant's driving Theresa Green's car and she's not around, which was weird. And now the defendant says, "I messed up." At this point, Joseph Butler told you that things are maybe starting to click, that the defendant and the victim may have gotten into it and the defendant may have done something. Clearly at this point, he doesn't know that the victim's body is in the trunk of the car that they just arranged to drop off at Walgreens, but he's starting to get concerned. He told you on the stand, Joseph Butler said, "I didn't want to be involved. I told him, don't tell me anymore." And he still doesn't want to be involved. He was trying to avoid the very thing that happened 2 days ago of him having to come into court, now many, many years later, to testify. He didn't want to be involved. But we do know that when Joseph Butler was questioned, along with Joyce Butler, he let the police into their apartment, take whatever photos you want, collect whatever evidence you want, dust fingerprints however you want, whatever you need. And we also know that Joseph Butler told the detectives about the party. He admitted slapping the victim, told them about them falling down the stairs, and told them about taking the car to Walgreens that following morning. When Joseph Butler and the defendant get back to the apartment after leaving the car at Walgreens, that's the last time the Butlers see the defendant. Why? Because he leaves, and he flees, and he leaves the state. The defendant gets in Henry Field's van that he had been using and leaves. He gets in the same van that is later found in Houston, Texas, burnt to a crisp, torched. You heard Terry Cool, the arson investigator, who was called to the scene of this fire. She told you that the fire was intentionally set. There was no license plate on the car. The gas cap had been removed. And the fire, there was basically kindling in the back, in the compartment area of that van. That fire was intentionally set. We also introduced the tag and title history. Houston Police Department examined this van and did a confidential VIN inspection, which is where they found the VIN number associated with this van. It was based on that VIN number that they determined this was the same van that had been reported stolen by Henry Fields in Orlando when this crime happened. We also introduced the tag and title history of this van, showing that the VIN numbers matched and showing that this van belonged to Henry Fields. And interestingly, this van was not reported by any other agency as being stolen. So this is not a situation where the defendant takes the van, drives it to Houston, and some other person just randomly steals the van. If that would have happened, it would have been reported stolen. It wasn't, because the defendant knew he was the one who stole it. And the evidence points to the defendant being the one who torched it, set it on fire, and burned it. Shortly after the van has been found burning, Officer Monroe Gage from the Houston Police Department makes contact with the defendant at a house on Barwick Street. Makes contact with the defendant in a place about 6 or 7 miles away from where this van was located. I think that's just a coincidence that both the van and the defendant are found several states over? Of course not. When Deputy Gage explained to you that when they found the defendant, another officer called him on the phone and said, "Come out the front door." The defendant doesn't come out the front door. He goes out the back door. When officers see him go out the back door, they start yelling at him. They're telling him to get down, comply, listen to our orders. The defendant didn't comply. Instead, the defendant ran. The defendant tried to escape. The defendant only stopped when he learned that there was going to be a canine released who was going to capture him and probably hurt him. The defendant tried to run from law enforcement when they were there to arrest him for the first-degree murder of Theresa Green. It's another piece of evidence to show that the defendant was the one that committed this murder. Otherwise, why run from the police? If he hadn't murdered Theresa Green, if he hadn't stolen the van, why run from the police? He ran because he knew what he did, he knew why the police were there, and he tried to escape the consequences. We call that consciousness of guilt. Going back to the apartment, how else do we know that the defendant was the one who killed Theresa Green? Crime scene investigators came to this apartment, and they did their work for several days. They processed the scene, they took pictures, they took photographs, they took swabs from various locations for potential DNA. They processed the victim's apartment, they processed the defendant's apartment downstairs in apartment number 9. Nothing of real relevance was found in the defendant's apartment, except they did find Theresa Green's fingerprint in there, which in and of itself isn't shocking considering they dated and probably frequented each other's apartments. But interestingly, when they processed the victim's apartment, the front door and the only entrance to the victim's apartment was not damaged. The door hadn't been kicked in, the door jamb wasn't broken, it wasn't pried open with a crowbar, the locking mechanism wasn't damaged. Nothing. No indication that the door was forced open to gain entry to Theresa Green's apartment. This shows that some random person just didn't walk up those stairs, kick the door in, go in, and kill Theresa Green. There's no damage. Whoever killed Theresa Green either knew her, was allowed in, or had access or a key to the apartment, like a boyfriend, like the defendant. What do they find inside Theresa Green's apartment? They find a watch. They find a Seiko watch, which was on the bathroom counter. We know that Octavius Hayes picked it up and put it on the counter. Significantly about the watch, though, they took swabs. Well, first of all, we know this wasn't a robbery. We have jewelry that's out in the open. The house was clean, tidy, hadn't been rummaged through. Valuables were still there. So we know this isn't a robbery. Somebody randomly just didn't break in and steal stuff. The watch, they took swabs from this watch and sent to Florida Department of Law Enforcement. And when those DNA analysis was done on the swab from the watch, we know that there was a major contributor of DNA on that watch. That came back to the defendant's DNA. We also know that the watch was broken. So again, is this evidence the end-all, be-all smoking gun? No. But it does show, well, we know that the defendant and victim were together throughout the night. They were dating, so it's not the end-all, be-all. But we do know that the defendants touched that watch with enough pressure to put DNA on it, and we know that watch was broken, indicative of some kind of a struggle or an altercation. Crime scene investigators also found blood in the apartment. When compared to the known DNA profile of Theresa Green, it was Theresa Green's blood. Could that blood have come from when Joseph Butler slapped her? Could have. But what else do we know that was found inside that apartment? When they walked in, watch, and when they walked in, they found this really big hole in the drywall. Now, Octavius Hayes told you that hole wasn't there when he left, because remember he went for a couple days to a friend's house over the weekend, Memorial Day weekend. He said that hole wasn't there when I left, but when I got back and came and found my mother wasn't there, that hole was there. So we know that that hole was created in a very short period of time, a short window. And we know this hole was not caused by Joseph Butler slapping the victim inside Joseph Butler's apartment. I submit to you that it's reasonable to believe that the hole was created during the altercation that eventually led to the defendant strangling the victim. All the evidence in this case, ladies and gentlemen, points to one person, points to the defendant as being the person who killed Theresa Green. This element, ladies and gentlemen, has been proven beyond any reasonable doubt. The third element the state has to prove is that there was a premeditated killing of Theresa Green. The judge read to you that killing with premeditation is killing after consciously deciding to do so. Decision must be present in the mind at the time of the killing, but the law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. That time must be long enough to allow reflection, and the premeditated intent to kill must occur before the killing. The law says premeditation can happen like that. As long as the person has enough time to think about what he is going to do and make the conscious decision to do it, that is premeditation. So what evidence do we have to show that this killing was premeditated? Dr. Utz talked to you about the photographs taken during Theresa Green's autopsy, and he explained to you that there were, in his opinion, various contusions or bruises. There were abrasions, scrapes, or marks, and evidence of blunt-type trauma inflicted upon the victim. He explained to you that there was swelling present in the right side of her neck, which he felt was caused by some type of trauma. He also noted the darkened areas on her lips, shoulder, her chest, things like that. And as a trained medical examiner, he is able to look at those injuries and determine, look, are those injuries simply from a darker-skinned individual and pigmentation of the skin? Are they a result of decomposition, or are the result of trauma? In his opinion, these areas were the result of trauma. Those findings of trauma are also consistent with the physical evidence at the scene, the broken watch, the hole in the drywall. Could some of this trauma maybe have been caused by Joseph Butler slapping her? Maybe the contusion on her lip. Could some of that be caused by her falling down the stairs? Maybe. But again, remember Lisa Moore, who said when they fell down, they slid down on their butts. But regardless, could some of this trauma have happened from falling? Could be. If those were the only injuries that we noted, that were noted on the autopsy, that might be a reasonable explanation, but they're not. She has other injuries that were clearly not caused by a slap and clearly not caused by falling. Those injuries combined with the circumstances of how her body was found, wrapped up, shoved in the trunk of a car, a locked trunk, all indicate that the victim was murdered and strangled. Theresa Green was an otherwise healthy 38-year-old woman, found wrapped in a blanket and her body in the trunk. We know she didn't do that to herself. We also know that she was not shot, she wasn't stabbed, she didn't have a brain bleed, she didn't have internal thoracic, internal bleeding, she didn't have any disease, she didn't have a heart attack, she didn't have a stroke. We know that she didn't die from alcohol poisoning. Even Dr. Arden said it's really unlikely she died from alcohol poisoning. So when you don't have any other explanation, one of the things you look at, and we know she didn't drown. So when you don't have any other explanation, one of the things you look at is strangulation. The injuries to her neck, both internally and externally, are indicative of strangulation. That strangulation is evidence of premeditation, ladies and gentlemen. Strangulation is a long process. This is not a situation where a gunshot into the head or stabbing into the heart where it causes an immediate death. Strangulation is a process. Strangulation occurs when the veins and or arteries leading to the brain are compressed such that oxygenated blood cannot get into the brain. If oxygenated blood can't get to the brain cannot function, and eventually the person becomes unconscious. And if that pressure is continually applied, even after the person is unconscious, that person eventually dies. You heard Dr. Utz explain all this. During this entire time, the pressure has to remain constant and continued pressure. That takes time. Second by second, minute by minute, holding that pressure. That's premeditation. But what's even more so, when this happens to a victim, the victim doesn't lay there passively and let things happen to her. The victim fights, the victim struggles, the victim crashes. The victim tries to remove that pressure from the neck. And as the victim fights, struggles, and moves around, that pressure is also moving and something is released, which causes oxygenated blood to come back into the brain, which causes the person's stay alive and conscious and aware. Only to the point where that pressure is occludes the arteries and the veins, does the person fall unconscious. That takes time. So what evidence do we have that the victim was struggling and fighting? Dr. Utz described these various linear marks on the side of her neck. This is on the right side, the side of the neck that has the swelling, as well as the other side of her neck. Dr. Utz explained to you that there are a couple possibilities of how this occurred. It could be from the defendant, the attacker, wrapping his hands around her neck and squeezing with the pressure and causing the fingernails to cause and leave these marks, which would be where that would be on her neck if that happened. It also could be from the victim's fingernails, who is reaching and clawing and trying to remove that pressure from her neck. We know Theresa Green was slapped by Joseph Butler. We know she tumbled down the stairs. Those actions are not going to cause those linear fingernail marks. What else do we know? Dr. Utz talked to you about the hyoid bone. The hyoid bone is that very protected internal structure around the chin area. And he told you that that area does not receive trauma very easily because it's so high up and is so protected. Dr. Utz explained to you that the hyoid bone is actually 3 different bones. And when a person gets older, in 40s, 50s or so, those bones start to fuse. But a person of her age, Mr. Green's age, they are still pliable and movable, and they have joints in them. Well, he explained to you when he looked at the photographs, and we see here, there was an area of hemorrhage, a dark reddened area of bleeding or hemorrhaging. Dr. Utz explained to you that in strangulation cases, he sometimes finds injury to a hyoid bone. Not always, but sometimes. In this case, there was hemorrhaging there. This injury is not caused by a slap in the face. It's not caused by somebody tumbling down the stairs. That's caused by pressure in that exact area of the throat causing the hemorrhage. The other side shows the same hemorrhaging. Dr. Utz explained to you that that is a hemorrhage and that the hyoid bone wasn't broken, it wasn't fractured, but it was dislocated, displaced. Why? Because of trauma, because of impact, because of the pressure. Now, Dr. Arden disagrees with Dr. Utz about some of these things, and I'll get into that in a little bit, probably during my second closing. But all of this evidence points to strangulation. And again, it's a lengthy process. The victim is struggling. Every second, second by second, minute by minute, the defendant has to make this conscious decision to maintain the pressure on his veins and arteries in order for the victim to fall unconscious. And even after that happens, he has to maintain that pressure to kill him. That's an opportunity to think. That's an opportunity to reflect. That's an opportunity, if he wants, to spare her life. But he chose not to. He chose to maintain that pressure. That is premeditation. His actions after the murder also show premeditation. After it's over, he doesn't say, "Oh my God, I just lost my mind. I can't believe I did that." He doesn't run out the door, bang on the butler's door, and say, "Oh my gosh, I need help. Please call. Theresa's hurt." He doesn't do any of that. Instead, he won't answer the door. He waits until the coast is clear, wraps the body up, throws it in her trunk, and drives the body far away from the apartment. Then flees, leaves the state. Ladies and gentlemen, the evidence has proven that while the defendant was striking and then strangling the victim, he consciously intended to kill her. No other explanation for doing that to somebody. During that process, he had the time to reflect and to think, and he chose not to release that pressure. Based on all the evidence in this case, the state has proven all 3 elements of first-degree murder. The judge read to you an instruction about lesser included offenses. And she read to you an instruction about second-degree murder and manslaughter. Lesser included offenses are just that. They are less than the crime charged. The crime charge is first-degree premeditated murder. And if the state has proven that beyond a reasonable doubt, you shouldn't even look at the lesser included offenses, because the judge will tell you that your verdict should be for the highest offense that has been proven beyond a reasonable doubt. Because the judge has read to you some of these things, and you read them, you have them in front of you as well, I'm going to just briefly touch on the lesser included offenses. There is second-degree murder, and second-degree murder doesn't require any proof of premeditation. That's why it's a lower crime. And the example I think that Mr. Marrero may have used to some of you in jury selection, the typical example we hear, is that a man gets home, walks in the bedroom, sees his wife in bed with another man, they're naked, there's a gun right next to him, without thinking, he reaches over, grabs the gun, and fires. No time to think, no time to reflect, no time to think, oh my gosh, this is what's happening, and I'm going to do this. He just reacts. That is the second-degree murder. We don't have that situation here, ladies and gentlemen. We have much more than that, because in this case, we have strangulation, we have thought, we have a conscious decision to maintain that pressure. He is guilty of the higher offense of premeditated first-degree murder. Manslaughter, she read to you that instruction as well. And manslaughter would be a situation where a person thinking a gun is unloaded points the gun at somebody and pulls the trigger, not thinking that there's any bullet in there, and there is, and the person dies. There is no intent to kill. There's no premeditation. That is a lesser crime than first-degree murder and a lesser crime than second-degree murder. Again, the evidence in this case has proven that element of premeditation, which is why this case is a first-degree murder case. If you look at all the evidence as a whole, apply your common sense, I submit to you that the only verdict in this case is guilty of first-degree premeditated murder. Thank you for your time, ladies and gentlemen.